Hello, this is Dr. Dennis Saccuzzo, and what we're doing here is trying to give you, in a very brief time, some essential principle that you can use to help you take on the bar exam one bite at a time. Now, these are things that we want you to try to nail down today. It's only going to take a few minutes, and you can easily do this. And we're on to evidence right now. Now, one of the things you're going to learn if you study past hypotheticals, and that's really the best way to learn all this, study the past hypotheticals. And in studying the past hypotheticals, I can tell you that you're going to find logical relevance is always an issue. Legal relevance is almost always an issue. Evidence, though relevant, may be excluded for certain reasons. That's the issue of legal relevance. Character evidence is almost always an issue. The basic rule you need to know is that evidence of defendant's character is inadmissible to show that the defendant acted in conformity therewith. It's a very important principle. You're going to find that hearsay is almost always an issue, and you're going to find that you're going to need to look for ways out of the hearsay rule. And then you're going to find quite often that privilege is an issue. So we want you to take this 5-step approach. Number one, begin by asking yourself, is the form of the question proper? In other words, can you object somehow? If you have an objection, make it. Next, ask yourself, what is the purpose of the evidence being presented? Then next, ask yourself, how is the evidence being presented? Presented by a witness, presented by a document. If presented by a witness, witness must be competent. If presented by a document, then the document has to conform with the best evidence rule. Next, ask yourself, is it hearsay? And then finally, is it privileged? This would be an approach to taking evidence questions. I want you to nail it down now. I want you to think about what I've just said, and I want you to practice as many past hypotheticals as you can.
Right, so evidence, we have a framework that we think works really well. If you take this in this order, you don't have to be married to it, but this is a good way to go through a discussion of a federal or even California evidence fact pattern. If you have a transcript style fact pattern, so one where they show you, here's a question by the prosecutor and here's an answer by some witness on the stand and so on, form objections are going to be something that you should maybe address. You could say, oh, there's an objection, calls for hearsay, objection, non-responsive, objection, calls for a narrative. Those are some of the favorite ones, calls for speculation, lacks personal knowledge, and so on. But if you have a transcript style, be looking, what form objections would you have maybe made, and quickly go through those. And then regardless of the style of the question, you always need to talk about each item of evidence, its logical and legal relevance is, maybe you don't have to talk about it every time, but that's something definitely to consider. But what is the purpose of the evidence? And oftentimes, not only is it necessary to do that, but it sets you up for some of these other issues when you look down towards character evidence and hearsay. If you have a good, strong, logical relevance analysis and understanding of what is the purpose that this evidence is coming in for. So logical legal relevance is important, but you don't need to spend pages on it, right? We want, you basically, since you're doing this for lots of items of evidence, and these evidence fact patterns are often racehorses, as we all see, this is of getting in and getting out and move. You just don't want to spend a page on this. You just maybe a half a paragraph and getting on to the next issue. Character evidence is also something to be looking for. It's not necessarily in every fact pattern. If you have a criminal fact pattern, the chances are that it's more likely to be present somewhere where you have someone charged with a crime, a prosecutor introduces some sort of bad character trait or some prior conduct, and there's this fear, will the jury or fact finder use that trait or the bad conduct against him rather than the evidence that goes to this particular charge, that he's on trial for. And in that case, you may bring it up. And typically they always have the mimic exception, where the prosecutor can say, yes, but we're not offering it to show conformity. It's going to show motive or intent or a mistake, a common scheme and plan or so on. They love that setup. So in criminal fact patterns, you're more likely to get something like that.
Just to emphasize, if it's a past act, like he's been arrested, then that any past act is going to raise this character evidence. And then past act, as Professor Poplin stated, past act or temperament We're going to prove he's a bully. We're going to prove he's mean. We're going to prove that he's high strung, and so on. So all of those are character conformity problems, and you need to raise character evidence. And in the bottom line is the character evidence normally won't come in unless you have a good exception.
Yeah, and there are exceptions. We won't go into them here, but just note that when you do have a setup in that criminal fact pattern, that's what you're looking for. But character evidence, when it is an issue, we'd all tell you it's one of those you have to really know and make sure you don't overlook, because it is one of those where they'll assign 10 to 15 points to it, and that can make or break, you passing that particular one if it's there. Other important piece to note and a framework is if you have in your call or in the fact pattern a document that's mentioned, somebody wrote down notes at the scene of an accident, there's a certificate of conviction coming in, whatever it is, a video, a recording, all of those are considered, quote, documents. But when you have a document, you have to be thinking, is it relevant? Is it hearsay? Is it authentic? Does it run afoul of our best evidence rules, or in California, the secondary evidence rule? Is it a privileged document? Is it a health, something that would be protected by HIPAA? And if you can kind of keep that brief checklist in mind anytime you have a document, that will make sure that you're on the right path and you go in and you're thinking of each one of those sort of sub issues.
In the past, they used to torture the people who wrote these hypotheticals. I haven't seen that so much recently. But in the past, they'd give us things like a monogram on a cigarette lighter and be very subtle about what evoked this issue of documentary evidence. Haven't seen it so much lately, but just be on the lookout for that.
Yeah, that would constitute a writing under either the federal or the California schemes. That's a good point.
So you have to ask yourself, how is the evidence being presented? And it's either going to be presented through a document or through a witness.
So, and that's a great segue. The next issue is witnesses. And when you have a witness, so if they're either bringing into, issue, somebody's on the stand and we're talking about, can they give this particular testimony? Maybe it's a transcript style and someone is saying something that maybe they really don't have in their personal knowledge. So we're going to an idea of competence, or that they don't have proper foundation for their testimony. But it also could be an issue of somebody's on the stand, they've given bad testimony or a testimony that hurts a person's case, and now on cross we're trying to attack that witness through impeachment. So maybe we have another character evidence issue, but now the character trait that's coming to bear is one for truthfulness or lack of truthfulness. And you guys will remember there's lots of different exceptions and rules that work there, but that's kind of the concept. If you have a witness, not only you're thinking of personal knowledge, you have to be thinking of impeachment, character, a lot of times convictions. So if a witness has a conviction, comes up here, and when you can and can't use particular evidence of convictions is something to note as well. And then hearsay. Hearsay, if you had to know only one thing or two things in evidence, obviously relevance, but hearsay is the big one. Lately, I've noticed that every single evidentiary call that's come in has some sort of hearsay tacked onto it. So you might have character evidence, you might have some sort of legal relevance issue like a policy exclusion, but then they toss in hearsay. And not only do you need to know what the hearsay rule is, you need to know ways around the rule. And we recommend, unless time doesn't permit, that you try to find maybe two colorable ways around. If it's a hearsay issue at every call and there's 8 calls, you probably won't have time to do that. But the rule of thumb where you start is, can you find a couple of ways around if time permits? And we've listed some of the main ones there. Party admissions, I'd say 80% of the fact patterns involve the use, or a party admission would help get out of the hearsay rule. PSI stands for present sense impression. That's in the federal courts. They don't have that in California. That's something to note. EU is excited utterance. You guys should all know what that is. And then in California, we call that a spontaneous statement. And then effect on the listener is a very common way to get around the hearsay rule, where you're saying it's not coming in for it's a truth. It's the effect that it had on someone who read, a piece of paper, or is listening to a comment that someone made. If you know those, I'd say 80+% of the time, you'll be able to get around hearsay, no problem. Double hearsay is one of their favorite issues. And where people go wrong, it's twofold. They either don't spot it, or they've missed it so much that now they just throw it in when it's not an issue. So we have a couple examples of what is double hearsay. If you had a witness on the stand and the witness was saying, Pat said that Mary said I did it. You've got this witness on the stand saying somebody told them what somebody else said. You've got multiple layers of hearsay there. Or if somehow, at trial, we were trying to introduce through a witness someone's notes, Pat's notes of what Mary said. We have Mary saying something, and then Pat is recording down what Mary said. You have two layers of hearsay, and each one of those has to be run through your hearsay test. You find some way around the hearsay rule, each component for it to be admissible as a part. Usually we see that in documents, or they also, like I said, they can do that with a witness saying multiple people said something.
The bar doesn't care whether you call it double hearsay or hearsay within hearsay or totem pole hearsay. They all mean the same thing.
Multiple layer hearsay, you name it. There's all certain different places, depending basically where you went to school or what area of the country you studied it, they accept anything. The idea is just when you have more than one layer of it, what is the general rule? Which is simple. Every layer has to meet a way around it. And then you discuss it. The easiest way or the best way to tackle it is to take it and say, like, level one, like, here's the first layer. Mary said ABC. Then Pat is repeating Mary's statement as the next layer, or writing down the notes. It's to be really clean in your organization. That way the grader knows, oh, we're talking about excited utterance as an exception to that first layer versus the other layer. It's making sure you're communicating exactly where it is you are in your analysis with that double hearsay. That's what makes it kind of messy. And then lastly, we have the issue of privilege, which there's a lot usually to it. But the good thing is they usually only test one type of privilege, or at least one category of privilege, which is the marital privileges. And there's a couple within that. But if you know the marital privileges, the confidential marital communications, or the spousal testimonial privilege, honestly, that's 98+% of the time they test privilege. Every now and then, especially on the MBE, you'll run into doctor-patient privilege, maybe one of the other other privileges that you've read about, but basically on the essays, chances are it's going to be marital.
And a PR question, they might test the attorney-client privilege.
Exactly. Yep, that's right.